final matter to come before us this morning is Joanne Doyle, further known as St. Clair, versus Jack St. Clair. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, if you want to reserve any time, I'm keeping the clock this morning to keep you abreast of the passage of time. The court's read the briefs and we are ready to proceed when you are.
Thank you. I would like to reserve 3 minutes for rebuttal. Dan Gibbons, 0065811, here on behalf of the appellant Joanne Doyle, formerly known as Joanne St. Clair. This matter arises out of an agreed divorce decree between the parties on February 12, 2009. It was a decree that had been extensively negotiated by the parties' counsel. And there are 2 provisions that are pertinent to this appeal. One was that Mr. St. Clair was to assume responsibility for all Lorain National Bank loans, which included one specific loan to the Steingles. The Steingles are Joanne Doyle's daughter and son-in-law. Both of the parties were actually co-makers of that loan. Both Mr. St. Clair and Ms. Doyle were co-makers of that loan. So that was going to be part of the settlement of the divorce. In addition, Mr. St. Clair agreed to pay to Ms. Doyle $1,250 per month for 132 months. This was for equalization. After the divorce was finalized, the Steingles were having problems from time to time paying the loan. Therefore, Mr. St. Clair would make payments on occasion. He would then deduct those payments that he made on the loan from the amount that he owed Ms. Doyle every month. As early as 2010, February 2010, and even through 2011, letters were sent by Ms. Doyle's counsel, James Geary, to Mr. St. Clair's counsel, Mr. Giardini, advising that this was not the agreement, that this was not acceptable to Ms. Doyle. And in fact, Ms. Doyle filed a show cause motion on the basis that in 2011, she subsequently withdrew that. Excuse me. In January 10th specifically, 2014, Ms. Doyle filed a motion to show cause against Mr. St. Clair again for these deductions. These deductions were not part of the divorce decree. They were never agreed to by Ms. Doyle, and they were not. They just weren't part of the parties' agreement. A couple months after Ms. Doyle filed her show cause motion in March of 2014, Mr. St. Clair filed a motion seeking to amend the divorce decree. He attached a document claiming that that document was the actual agreement of the parties, it was the intent of the parties, and this document, which is attached to his motion, is Exhibit C. I'll refer to it as Exhibit C for purposes here, was the actual agreement and wanted the divorce decree amended to reflect this. The Exhibit C purportedly allowed him to deduct payments that he made on the Stein loan. That I should say that it made Joanne responsible for the Stein loan, not Mr. St. Clair. Greatly changed the terms of what had been agreed to and filed with the court. Ms. Doyle filed an opposition to this motion. The court had a the trial court had a non-evidentiary hearing in May, middle of May. Arguments only were presented by the attorneys.
There were affidavits presented afterwards? Is that
yes, yes. The court did give permission for post-trial briefs to be submitted, which they were. And in fact, the opposition brief that had been filed even before the hearing was signed and notarized by Ms. Doyle. But we submitted another affidavit with the post-trial brief. And that was unequivocal, that this was never the agreement of the parties. This had never been negotiated. This was never incorporated into the final decree. There were also letters between counsel that were submitted, also showing that even after the decree, Mr. Geary indicated indicated that deducting was not acceptable. There was even a letter from Mr. Giardini back in October of 2010, which acknowledged that there was no provision in the divorce decree regarding Joanne Doyle taking responsibility for the Steinman loan. In January of 2014, May 28th of 2014, filed a post-hearing brief, attached those letters between counsel, attached the affidavit. June trial court granted the motion to modify, so that there was a course of conduct, despite the fact that no evidence had been taken, no testimony had been taken. Also, despite the fact that even though Mr. St. Clair's motion acknowledges that he at least had knowledge of, or had a belief that there was some sort of error or mistake with the divorce decree as early as 2011. I'm sorry. Still, we're talking, even if he knew in 2011, as late as 2011, still didn't file anything, took no action with the trial court until 2014. And even then, not until after Ms. Doyle filed her motion to show cause. In his motion, Mr. St. Clair asks for relief on the basis that there was a mistake. There is unequivocally a one-year time limit to file for a mistake. Subsequently, it was argued that B5 somehow gives carte blanche for the court to make a determination or grant relief on any other reason. That would be in the interest of justice. But the fact is that B5 does not supplant 1 through 4. B5 only comes into play if none of the other provisions under 16B have been met. In this case, it was clear that if there was a mistake, it was a long time ago. We dispute that there was any mistake whatsoever. We believe that the divorce decree accurately reflects what the parties' agreement was. But bottom line is that, if Mr. St. Clair had a belief that there was some sort of error with the divorce decree, he needed to make some sort of an effort to correct that long before 2014. The divorce was in 2009, so at the latest he would have been looking in 2010. Trial court, we believe the trial court erred in applying B5, 60B5 to this case, because clearly the only basis for this was a mistake, subject to the one-year time file. Also, there was arguments regarding mutual mistake. Mutual mistake means that both parties are mistaken. In this particular instance, it is very clear that both parties were not mistaken. Ms. Doyle's affidavits are pretty clear. The terms of the divorce decree are the terms that she agreed to. There was no mistake on her part. Therefore, if in fact there was a mistake on Mr. St. Clair's part, he needs to show that there is some sort of justification for this. Justification for the mistake. The fact is that by his own admission, he knew at least since December 2011, or believed at least since December of 2011, that there was some sort of error, that there was something wrong with the document. And again, did nothing. No action whatsoever. So quite frankly, I don't believe that there was any kind of mistake at all. Last issue really is the evidentiary hearing. In Richard v. Seidner, the Supreme Court said an evidentiary hearing should be held where there are allegations of operative facts which are material to the case in which we warrant relief. In this case, even assuming that the motion was timely filed, which I really don't believe it was, but even assuming that, at the very least, the court should have taken some sort of evidence about this.
Well, the court did take evidence, didn't it?
Took the affidavits.
It's evidence.
It is.
Testimony.
It is. It is. Yeah, and bottom line is that when you look at this in total, there was a divorce decree. There were seriously negotiated and long negotiated terms, and if Mr. St. Clair felt that there was a mistake, should have filed it long before 2014.
Are we going to find, just on this issue of the evidentiary hearing, anything in the record where the parties, either parties requested the court to permit the call of witnesses and examination?
No, there was no request. So, thank you very much.
May it please the court, my name is Anthony Giardini. I'm here on behalf of Defendant Jack St. Clair. Along with these, since turning 16, there was a mistake in this case, but the mistake wasn't about what the agreement was, because the two parties negotiated that agreement themselves. Sometimes, we encourage our clients to get together and work things out, and in this case, Jack and Joanne St. Clair did. And after they worked things out, they prepared a document that is attached to it's in the record, it's not Exhibit C, by the way, it's Exhibit A, and it's, I think, page 14 of the record. In any event, in that document, the parties themselves prepared, it indicated that Jack would assume responsibility for all the Lorain National Bank loans, except for loan number 34105, which he and his wife Joanne had co-signed on behalf of Joanne's daughter, an adult lady who had back taxes. And it was a large loan, it was like $40,000 or $50,000 loan that they co-signed for the Steins. And they had also co-signed for a loan for one of Jack's children from the prior marriage. And Jack's son paid his loan, but about a week after this divorce was done, and a separation agreement was incorporated into the judgment decree, a separation agreement which my client believed included the language, except for loan 34105, he'll be responsible for the payment of the loans. A week after the divorce is done, lo and behold, the Steinbills miss payment on the loan. The ink isn't dry on the separation agreement of the judgment entry, and the Steinbills miss payment. And Mr. St. Clair, knowing what the agreement was between him and his former wife, Joanne, and believing that all that agreement had been incorporated into their separation agreement, deducts the payment he makes on behalf of the Steinbills' Lorain National Bank loan from the equalization payment that Jack owed to Joanne. And he doesn't just deduct it. He does it and sends her a note saying, Joanne, I deducted the $600 and some odd dollars that I paid on your daughter's loan because that was our agreement. And he just thinks he's following the agreement that he and she made and that he believes is actually in the separation agreement. What is Joanne's response to that? February 20th, 9 days after the divorce is done, nothing. He does it again a month later, nothing. He does it again a month later, nothing. 5 times in the first year after their divorce, not a peep out of Joanne about why are you deducting these things? This is your responsibility. She didn't, I would submit to this court, because that was their agreement. She understood it was their agreement, and even though, due to some error of counsel, we didn't get that one phrase in the separation agreement, she understood it, and he understood it, and they behaved that way. Now, it is true that a year later, Attorney Deary wrote to me about a bunch of other matters that his client was complaining about. He doesn't complain about the deductions, but he makes a cryptic comment in the last sentence of his letter that says, Jack is making the payments on Steinbills' loan at his own risk. This is already a year later, and after he's made all these deductions, I had no idea what he was talking about. A year after that, in 2010, I finally realized what he was talking about because he raises the issue again. And I did write to him and said, you know, I don't see it in the separation agreement, but I know that it was discussed, and Jack says that he and she had agreed to it. It's in a document that they presented to me.
And where are we in terms of time at this point?
And now we are 2 years post, a little over 2 years post-divorce, and, I'm sorry, yes, pretty close to 2 years post-divorce, and by then he has deducted that payment at least 5 times, Your Honor.
And what is the time frame between that moment and the time that the motion to vacate, or not to vacate, the motion that you filed to modify?
4 years, Your Honor, or almost 4 years.
Okay.
And one might say, well, what the heck were you doing? Well, Your Honor, after I explained to Jim, to Mr. Geary, in 2010, I don't see it, but I know that they agreed to it, and there were conversations too. Nothing happened. Now, we're making the deductions. We're living up to the agreement as we understand the agreement that they made. So if anybody is going to take action, it would be Joanne for contempt. You're not living up to the agreement because you're shorting me $653 every time my daughter misses her loan payment.
So, well, I understand the position that you take, that logically speaking, the onus is on her to object and to raise this issue. But if we look at this in the context of a motion to vacate or a motion to modify, and particularly under 60B, counsel raises an interesting point about this issue of mistake and whether the trial court had the ability to consider that under 60B5 as opposed to 60B1. So we're not looking at, well, you know, in the world of reason and common sense, it should have been this, but now we're looking at what the statute, not the statute, but the rules require.
And it's a great point, Your Honor, and here's the answer to it. Rule 60B5 was specifically written as a catch-all to deal with unusual circumstances. And here's the unusual circumstance. We could not have, because we did not, first of all, we don't think there was a mistake in terms of what the agreement was. We believe the agreement was that Mr. St. Clair would be responsible for all Lorain National Bank loans except the one that he co-signed with Joanne for her daughter. That's what we believe the agreement was. And we offer as proof to you, and we offered as proof to Judge Swensky, the fact that for 1 year, before the first issue was ever raised, they operated that way. So we were already past the 1 year time frame for dealing with it within a year. We were already past that. Not through our fault, because we're operating on the assumption that it's in the separation agreement, it's what we all agreed to, and if the Steinbills hadn't made their payment 2 years after, there might be an argument here. But the Steinbills, they default on their payment week 1 after the divorce decree. He deducts it week 1 after the divorce decree. So that's why we believe the onus was on them. So she puts us in an impossible situation, Your Honor. We couldn't file within 1 year because the year was already gone before she raises the issue. On top of that, not only does she allow him to make the deductions without complaint for a full year, when she does finally file a motion to show cause in 2011, she doesn't raise this issue. She raises a bunch of other issues that he supposedly hadn't done. By then, he had deducted 8 payments. So he theoretically, according to her, based on her agreement, he owes her 8 times almost $500, I'm sorry, over $600, $4,800. She does not ask the court to have him held in contempt for not making those payments, despite the fact that she files a motion to show cause on other issues, which to us, again, proved that she understood what the agreement was. She wasn't going to file a show cause motion against him because she knew what she had agreed to, which is why we never did anything, Your Honor. Even when she did file a motion to show cause, there was some transfer of property and a few other issues that she filed a motion to show cause on. She doesn't raise this issue. That's 2011. The first time she files a show cause motion on this issue, the deduction on the equalization payments caused by the Steiner loan, was 2014, 5 years later. So what we were really doing was defending on a motion to show cause, and we were asking for the court for relief from judgment on this. Basically, we argued to Judge Swensky, don't hold him in contempt. He did what he believed the agreement was, and what he knows the agreement was based on his own conversations with his wife. And as proof of that, Judge Swensky, here is her course of conduct over the past 5 years. Not raising the issue. Never once raised the issue with the court. 5 years. Her lawyer raised the question more than a year after, but he had been making the deductions from a week after the divorce, which is why we think Rule 60b-5 is the appropriate rule. It's the catch-all rule. And the standard of review here is abuse of discretion. Did Judge Swensky abuse her discretion? And that means that was her ruling unconscionable? Was it arbitrary? Was it unreasonable? But, Your Honor, I would submit to the court that when two parties reach an agreement on their own, a contract, and if the lawyers goof up somehow and don't get it exactly right in their contract, but the two parties operate that way, they have their course of conduct. In other words, they know what their deal is and they proceed along with that deal. That one of those parties can't come around five years later and say, I want you held in contempt because this contract was a part of a divorce judgment, and she's not suing him for breach of contract, she's pursuing him for contempt. Well, if that wasn't the agreement, why not do it in 2011 when she finally did file her motion to show cause on some other issues on that same contract? Didn't do it. Why didn't she file it, the first week? When two people get divorced, usually that's when feelings are the hardest. One would think that she would have walked right back to her lawyer's office and say, he just shorted me $653 on my first payment, and I want my money. And she didn't do that. And she didn't do it in March, and she didn't do it in April, and she didn't do it in May. She didn't do it in 2009 at all. She didn't do it in 2010. She didn't do it in 2011 when she filed a motion to show cause on other issues. She didn't do it in 2012, 13, or 14. And Your Honor, she put my client in an impossible situation. And quite honestly, maybe we should have rushed right into court about something, but we believe because of her course of conduct in accepting the reduced payments without objection, that this was not an issue. Honestly, when the motion to show cause was filed in 2014, I was shocked. I couldn't believe it. I said, what is going on here? And I've never, to this day, gotten a clear explanation of that. I think the case law is pretty clear. Whitman, the Supreme Court case, says that a separation agreement can be modified without undoing the divorce, where the evidence is that there was an agreement reached that, for whatever reason, didn't get fully incorporated into the separation agreement. We're not really talking about a judgment decree by the court. We're really talking about a contract that was then incorporated into a judgment decree. And I think that's also an important distinction. And this really wouldn't have been a material issue between the parties if the Steiners if her daughter had made her own payments. She didn't, and unfortunately, Mom and stepdad then had to step in and do it. But Mom and stepdad had divorced a week before that, and Mom and stepdad had reached an agreement that Mom's going to be responsible for this. And that's really what this is about. I don't believe that this argument about there wasn't an evidentiary hearing has any merit at all. We submitted my client's affidavit with our motion. So in March of 2014, when we filed our motion to to defend against the show cause motion and modify the separation agreement so that it reflected the actual agreement of the parties. We submitted his affidavit. The hearing didn't take place for another 2 months after that in May 2014. My client was in court on May of 2014 prepared to testify if it was necessary or answer the judge's questions if necessary. His affidavit was already on file. The the plaintiff, the appellant, didn't submit anything. She didn't show up to the May 2014 hearing that the Judge Swinski held. And then she doesn't submit an affidavit until after the hearing. Now, I objected to that, and I moved it to be stricken from the record. Judge Swinski overruled my motion and allowed the affidavit in. So she had the affidavit of Joanne, which she had my client's affidavit for 2 months prior to the hearing. My client was in court. No one from the appellant's side asked to put him on the witness stand and cross-examine him or do anything else like that. I just don't think that argument has. And plus, it doesn't say you have to have an evidentiary hearing. So you may have one. I believe that those affidavits and all the letters and other documents that were attached to them were ample evidence of what went on here, and for the court to reasonably conclude that, yes, these two had an agreement. It's clear that they had an agreement because of how she behaved for 5 years after the divorce decree. Unless the court has any other questions, Steve.
Judges, again, while I understand that Mr. St. Clair wishes to absolve himself of any responsibility for what he needed to do, the fact remains. In July of 2011, there was a letter from Mr. Geary, and this is all attached to Ms. St. Clair, or Ms. Doyle's post-hearing brief. Letters July of 2011, October of 2011, February of 2010, all addressing this issue, and specifically noting that deduction from the monies owed to Ms. Doyle were not acceptable, that it wasn't part of the agreement. Mr. Giardini even acknowledged in his letter of October 2011 that he didn't see such an agreement in any of the provisions of the divorce decree. There was no course of conduct at all. Ms. Doyle never agreed to this. This is a very substantial change in the terms of the divorce decree. If Mr. St. Clair wished to proceed without trying to modify it, or at least agree to report his argument that he believed that there was a mistake, that's on him. He needed to do that within a year. He did not do that. There was no course of conduct. Even before the hearing, despite what Mr. Giardini has just stated, before the hearing, an opposition brief to Mr. St. Clair's motion was filed, and it was signed and notarized by Ms. Doyle, stating that the facts contained therein and the argument contained therein were accurate. So yeah, even before the hearing, there was sworn testimony or sworn affidavit, sworn statement from Ms. Doyle. The court ordered that there be post-trial briefs submitted, so we submitted one with the affidavit and with the exhibits. The fact that my client wasn't at the hearing is completely irrelevant because it was determined before we even came that it was going to be a non-evidentiary hearing, that there was no evidence, there was no testimony that we take. Bottom line here is Mr. St. Clair had a year from the day of the divorce decree in which to seek some sort of relief under 60B1. He did not do that. That's on him. He's shown no justification whatsoever for trying to say now that 60B5 somehow applies. The reality is that he didn't do it. For whatever reason, he didn't. But the end result is that he didn't. So, yeah, we would ask the court reverse the trial court's decision. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website. We are adjourned until Tuesday.